Welcome back to another J. Harris Academy of Police Training Roll Call. I'm Joey Sperlazza. Today we're going to be discussing New Jersey v. Dale Edwards. This case discusses well-established principles already related to motor vehicle stops, searches, as well as Miranda. This is New Jersey v. Dale Edwards, decided on November 12th, 2024. This is an Appellate Division unpublished decision. So the incident in question happened on April 16th, 2022. The officer observed a vehicle do an illegal U-turn. He initiates a motor vehicle stop. The vehicle pulls into a business in the middle of the lot. Officer approaches, activates his body camera, asks for license, registration, proof of insurance, and the defendant produces a Montana driver's license. There was also a passenger in the vehicle. On his approach, the officer states that he was extremely nervous, shaking, avoiding eye contact, and he noticed that his pupils were extremely constricted. The officer later testified that based on his training and experience, pinpoint pupils are often associated with being under the influence of narcotics or in possession of narcotics. We all know, especially with related to Narcan training, opiates will constrict your pupils. Some of the people we interact with, their pupils are so constricted, all you see is the color of their eyes. That is a huge indicator that somebody is under the influence of CDS. The officer returns to his vehicle. When he goes back to the vehicle, he runs the driver, and he comes back with a non-extraditable warrant out of Montana. Non-extraditable means that we can't arrest him here in New Jersey. He's only able to be arrested in Montana. He returns to the vehicle, and he questions the driver as to what happened back home, and the driver states, "Different choices, drugs." The officer then asks for consent to search the vehicle. Defendant says, "It's not my car. I cannot consent to search of the vehicle." The officer then gave him three options: consent to a search of the vehicle, the officer can get a canine, or the defendant can just tell him where the drugs are. Ultimately, the defendant told him that there are drugs inside of the vehicle. In response to the officer's inquiry, "Do you want to show me where the drugs are?" the defendant directed the officer to the driver's side compartment, where the officer located three plastic red containers. Two were empty and one contained a crystal-like substance suspected to be methamphetamine. The officer questioned the defendant about whether the drugs were his or the passenger's. He initially said that they weren't his, but then he later admitted that they were his. Officer also questioned about the last time he used methamphetamine, and he stated last night. Officer arrested the defendant for methamphetamine, and then he searched the rest of the vehicle. On search, he found a New Hampshire driver's license with the defendant's picture on it, but a different name, a social security card with a different name on it, and a loaded 9mm handgun. The defendant was indicted on various charges. The defendant then makes a motion to suppress his statements, both verbal and nonverbal, made at the scene of the stop and the physical evidence seized thereafter. The motion judge stated that there was a traffic violation which meets the threshold of at least RAS to stop that vehicle. He then cited State v. Hickman, which is an Appellate Division decision in 2000. The judge noted, "Roadside questioning of a motorist was not transformed into a custodial interrogation requiring Miranda warnings simply because an officer's questioning was accusatory in nature or designed to elicit incriminating evidence. In distinguishing between a custodial interrogation and an investigatory procedure, the motion judge explained the court must view objectively the totality of the circumstances, including the length of a detention, the time and place of the questioning or interrogation, and the conduct of the police officers. Considering the totality of the circumstances, defendant's statements on scene were voluntary, not obtained in violation of any rights, and accordingly were admissible. Any statements made post-arrest were subject to requirements of Miranda." As to the search of the vehicle and the seizure of physical evidence, the motion judge ruled that the defendant, in response to officers' three options for searching the motor vehicle, told officer that there were drugs in the vehicle and showed him where the drugs were, thereby providing probable cause for the search of the automobile. Once there was probable cause, the matter squarely fell under the automobile exception to the warrant requirement. Therefore, the judge concluded that the officer's search of the vehicle did not violate defendant's rights to be free from unreasonable searches and seizures, and the items from the vehicle were admissible at trial. The defendant appealed. He's arguing, number one, the police prolonged the detention and requested consent without reasonable suspicion. The point two was defendant's confession was involuntary. Both the confession and the derivative evidence should be suppressed. And point three, the suppression of the defendant's responses to officers' questions required because the defendant was in custody when the police questioned him without first advising him of his rights. So the defendant does not challenge the lawful stop, but he contends that because the police unlawfully prolonged the detention and sought consent to search without reasonable suspicion of criminal activity, all the evidence must be suppressed. The appellate court rejected this allegation. The court ruled that the officer observed that the defendant's pupils were extremely constricted. The officer's training and experience informed him that someone with extremely constricted pupils was usually under the influence or in possession of a narcotic. Defendant was extremely nervous, shaking, and avoiding eye contact, and his outstanding warrant provided officers with reasonable suspicion to prolong the stop and to broaden his inquiry into suspicions that the defendant possessed or was under the influence of illegal drugs. Given that officer had reasonable suspicion regarding his drug possession or use, his request that the defendant consent to a search of the motor vehicle and the suggestion that he could bring a canine to sniff the motor vehicle were appropriate in these circumstances. During an otherwise lawful traffic stop, a police officer may inquire into matters unrelated to the justification for the traffic stop. Beyond determining whether to issue a traffic ticket, an officer's mission includes ordinary inquiries incident to the traffic stop. This includes checking the driver's license, determining whether there is an outstanding warrant against the driver, and inspecting the automobile's registration and proof of insurance. When, as a result of the initial stop or further inquiries, the circumstances give rise to suspicions unrelated to the traffic offense, an officer may broaden the inquiry and satisfy those suspicions. An officer's ability to pursue incidental inquiries, however, is not without limitations. In determining whether reasonable suspicion exists, a court must consider the totality of the circumstances. Courts must not engage in a divide and conquer analysis by looking at each fact in isolation. Therefore, the reasonable suspicion inquiry considers officers' background and training and permits them to draw on their own experience and specialized training to make inferences from and deductions about the cumulative information available to them that might elude an untrained person. Applying the totality of the circumstances, the defendant's pupils were extremely constricted. Officers' training and experience informed him that someone with extremely constricted pupils was usually under the influence of or in possession of narcotics. The defendant's extreme nervousness, shaking, and avoiding eye contact, and the defendant's outstanding warrant provided the officer with reasonable suspicion to prolong the stop and to broaden his inquiry into suspicions that defendant possessed or was under the influence of illegal drugs. Given that the officer had reasonable suspicion regarding defendant's drug possession or use, his request that defendant consent to a search of the motor vehicle and the suggestion that he could bring a canine to sniff the motor vehicle were appropriate in these circumstances. The defendant contends that the officer had no reasonable suspicion to prolong the stop, and therefore the officer's suggestion that the defendant could consent to a search of the vehicle, could just tell the officer where the drugs were, or the officer could get a canine to sniff the motor vehicle, threatened an unjustified course of conduct, and coerced the defendant's admission there were drugs in the motor vehicle, and therefore the admission and all derivative evidence must be suppressed. The court looked at this. The officer and defendant were outside, in daylight, along a busy street with motorists. The entire exchange took mere minutes, supporting the conclusion that defendant was not overborne. The court reviewed the body-worn camera footage, which depicted a scene where only the officer and defendant were interacting. The officer and defendant maintained a reasonable physical distance between one another, and the officer's tone was calm and not aggressive or threatening. The defendant's admission was voluntary. The officer had a reasonable suspicion of the defendant's illegal drug possession or being under the influence of illegal drugs. Therefore, the officer could extend the stop to satisfy his suspicion and could request consent to search the defendant's motor vehicle or advise the defendant a canine sniff could be conducted. Officers' actions did not coerce the defendant to confess by engaging in and threatening to engage in an unjustified course of conduct. No suppression of physical evidence is required. The stop was proper, supported by reasonable articulable suspicion. The search was proper. The extension of the stop was proper. So now let's address the Miranda issues that are brought up. To back up real quick to the consent aspect. Knowingly, intelligently, and voluntarily. That's what's required for somebody to waive their rights under consent, as well as with Miranda. We cannot coerce people. That was the argument that was given under our section with consent. So now, with Miranda, custody plus interrogation equals Miranda. So the question here is, at what point was he in custody? Because if the questioning continued after he was in custody and no Miranda warnings were given, those statements have to be suppressed. Persons that are temporarily detained pursuant to ordinary traffic stops are not in custody for the purposes of Miranda. However, if a motorist who has been detained pursuant to a traffic stop thereafter is subjected to treatment that renders him or her in custody for practical purposes, he or she will be entitled to the full panoply of protections prescribed by Miranda. When was the defendant subjected to custodial interrogation and thus entitled to Miranda warnings? The defendant argued that he was in custody when the officer made it clear he was not going to let him leave after completing the tasks related to the motor vehicle stop. The defendant contends that the officer made clear that he was not free to leave unless he consented to a search or confessed, and therefore the officer needed to read him Miranda rights. Alternatively, the defendant argues he was in custody after the officer obtained probable cause for an arrest. The defendant asserts that after he indicated that there were in fact drugs in the car, police had probable cause for an arrest and were required to read the defendant his Miranda rights prior to asking him incriminating questions. The state contends that the defendant was in custody for Miranda purposes when the officer told the defendant that he was going to be under arrest. The motion judge concluded that all of the defendant's pre-arrest statements are admissible. The officer had a reasonable suspicion that the defendant was in possession of or under the influence of illegal drugs. Therefore, within a reasonable period, the officer had the authority to inquire without providing Miranda warnings. Thus, when the officer inquired as to whether the defendant possessed drugs, the defendant was not subject to a custodial interrogation under Miranda. Consequently, his admission was not subject to suppression. However, once the defendant admitted to possessing illegal drugs, a reasonable police officer would have believed probable cause existed to arrest the defendant, and they would not have permitted the defendant to leave. Similarly, a reasonable person in the defendant's position would not have believed that he was free to leave. The officer's subsequent questions, whether the defendant wanted to show him where the drugs were in the car, to whom the drugs belonged, and where he got the drugs, and the last time he did drugs, targeted the defendant as a suspect. After admitting to the possession of illegal drugs, the defendant was in custody, and the officer was required to administer Miranda warnings to the defendant. His post-admission responses should have been suppressed under Miranda, and they remand for further proceedings. So in this case that's before us today, those statements that are actually being suppressed are going to be irrelevant to what his convictions were for the handgun possession as well as the narcotics possession. However, it's a stern reminder to us that on a traffic stop, once we get to the point of probable cause to arrest, at that point we have to stop our line of questioning, issue Miranda warnings, and then we can continue. Imagine if the handgun in his car, he said, "Whose gun is this?" The defendant that said, "Oh, that's mine. I just used it to kill somebody." That statement's going to be suppressed because Miranda warnings would have been required at that point. So remember, roadside stop, you establish probable cause to arrest, Miranda, and then continue all of your roadside questioning questions. It'll be considered a custody interrogation. I'd like to compare this case to State versus Raheem O'Neal. This case is something that we've discussed extensively in the past, but in that, similar to this case, the Miranda was a harmless error. The statements that were given post the point where they should have issued Miranda are going to be irrelevant to the ultimate conviction of the narcotics possession and, in this case, the handgun possession. Thanks for joining me on this roll call. Until next time, stay safe.
This podcast is brought to you by the J. Harris Academy of Police Training. J. Harris Academy of Police Training is based in New Jersey and provides law enforcement training services nationwide for promotional examinations, use of force, supervisory development, and other key areas within law enforcement. This podcast is utilized to discuss key topics occurring within the profession. The opinions and information provided is for entertainment purposes only. In an effort to provide this, we often purposely discuss opposite views and opinions to spark conversation and develop discussion points. The contents of the show and show notes are all copyrighted. All blog posts, podcasts, and show notes that are distributed to the public for free can be redistributed via hard copy or electronic copy for free only if the J. Harris Academy of Police Training is included as the acknowledged author within the actual media that is redistributed. This entire disclaimer also applies to any guests or contributors to the podcast or blog. Under no circumstances shall the J. Harris Academy of Police Training, any guests, contributors to the podcast or blog, or any employees, associates, or affiliates of the company be responsible for damages arising from the use of the information provided.